Hello everyone, and welcome to this webinar on patents, strategy and practical aspects. To share his insights with us this evening, we have Vaibhav Khanna, who is the head of intellectual property at Sterlite Technologies Limited. Welcome, Vaibhav.
Thank you very much. And I'm really excited to be on this platform and look forward to have a barrage of questions coming from Deepshika's side and the participant side.
Right. And we also have with us Deepshika. She has been really instrumental in framing and putting this webinar together and communicating with Vaibhav over the last few days to get this webinar in place. Hi, Deepshika.
Hello, Komal, and hello everybody online. And I look forward to this webinar.
Okay. Just to ensure Vaibhav will be sharing his insights with us today on some really practical aspects in relation to patents, something that we will not be able to easily find with research. And he shall be dealing with a strategy in relation to patents, the monetization of the patents and related legislations or issues. So over to you, Deepshika, and you can begin with the questions, please.
Okay, so Vaibhav, the first question that I'd like to ask is that how does an inventor benefit from registering his invention? What are the benefits of getting your invention registered?
Deepshika, I'll kind of little bit rephrase your question. I'll put it this way, that is there a value in registering a patent for an invention? If you really ask me a very short answer to this, the plain answer, vanilla answer would be no, there is no value to it. Patent is just a tool to achieve business objectives. So as long as you are patenting your invention and not really achieving the tools or not achieving the goals that it is intended to achieve, you are not really creating a value to it. So from that standpoint, value unless and until we really know what we want to do with that. Just to put things in a little bit perspective, when we say the kind of value we are looking at from a patent, first thing that comes out to people's mind is probably seeking royalty or stopping competition from using our own product. There are two important values, and probably these are the two important ways in which people or organizations realize value from them. But having said that, these are the two very glorified ways of doing it, because this is possibly the not the most common way of realizing value from a patent. But there are several other ways people realize value. They are more a non-tangible way in many senses. Say, for example, patent a usefulness of a patent for an startup. So it could be something like securing a financing. It could be an equity finance. It could be debt finance from financial institutions like Citigroup. Even they are the people who lend money based on the patents. If we are talking about a medium-sized Indian organization who really want to ventures into, say, for example, a US market, a technology company, then for them, it is very important to have a set of patents, so that, because when they enter in a developed market, they will be facing several IP issues. So unless and until they have their own patent portfolio to back it up, they'll not be able to do that. And if you talk about really certain companies which operate in a very commoditized market, for example, let's say material science companies, they come out with a specialty material. It's like very easy for anyone to copy that material. And once it is copied, it can commoditize your market, it can erode your margins, and everybody would be supplying at cost plus certain basis. So it will not make business sense to really innovate. For example, somebody comes out with a toothpaste, very next day or probably in a week's time, a similar toothpaste with a salt or something would be there in the market. Several Fortune 500 companies, and probably there are two of them in Fortune 20 as well, whose sole job is to make materials. How they are able to do that is they are able to put IP at the center of their strategy, in the center of their business, and they are able to attract customers, they are able to gain customers, they are able to retain them, they are able to get profit margin out of it, and they are obviously able to keep the competition away and to spoil the market. So it depends upon what is the objective that a person has in mind. And yes, branding is also a very viable objective for an inventor, saying that I have a 20 patents in my name. That really adds credibility to his portfolio. Same goes within PhD thesis. I have several number of papers. Yes, so it's great. But does it have commercial value? Probably yes, probably no. But if you have several patents in your name, that means you have invested a lot of money in it, a lot of efforts in it. So that adds a lot of branding, a lot of gravitas in the work that you have done. So depending upon what we are doing, what we are trying to achieve by filing a patent, so it has value, but at the end of the day, it needs to be put to use. My answer that it every part portfolio building exercise, either driven by an CEO or by an IP professional or by a lawyer. It depends upon what is it that we are trying to achieve. And unfortunately, what has happened is uh, most companies, and I'm not talking about only Indian companies, most most companies across the globe, even the biggest of the multinationals, a lot of them IP functions as a in a silos. Because it function in a silos, uh, the true value most of the times is never realized. For example, talk about Motorola, for example. Everybody obviously has heard about Motorola. That's a company that was unable to pay salaries to its employees, that was unable to pay their dues to its vendors, that were unable to raise working capital for its operations. They went into bankruptcy, were able to sell their patent portfolio for several $100 million. That's over and above the securitization money. So it is something like there's a person who has some X amount of household expense every month, but he also has an asset, 100 crores asset lying idle, and he becomes defaulter and he is not able to pay his dues. He's dragged into litigation, but he's not able to unlock value that is lying in those assets. So that's the point that I'm trying to make here is kind of studies that we do, kind of understanding we do. For some reasons, the practical or applied part of IP has been missing in most of the courses that we have, and not really on the courses because it is missing on the courses across the globe, most of them. So that's why it's missing in most of the organizations as well. There are few organizations for which it's at the center of it and they're really reaping benefits out of it. So I think that somewhat answers your question.
Oh, yes. Thank you for your answer. The next question that I'd like to ask is, for example, there's an industry which is primarily manufacture and invention based. So, how
Mhm.
important is it for an industry which is a manufacture and invention based industry
Mhm.
is to have a patent strategy? And if it is
Mhm.
important for them to have a patent strategy, how
Mhm.
are they supposed to go about it?
Sure, great. So when we talk about patent strategy, so essentially there are three components to it. First component, again, we'll come back to the same question. First component is the purpose. Why are you wanting to have a patent portfolio? Why do you want to build patent portfolio? What is it at the end of the day you are trying to achieve? So that's the first pillar of the strategy. Second pillar is the kind of market that you are operating in. When we say kind of market that you are operating in, we are essentially talking about uh, is it a likely really a commoditized market, or is it a market wherein industry moves really fast? It's a very dynamic market, like say telecom market, wherein a life cycle of innovation is not more than 3 years, 2 years, 4 years. 2-3 years, there's a new technology that is replacing the entire existing set of technologies, or you are operating in a very, very lethargic, very slow moving industry, such like, for example, power sector. So things won't change for several years, or maybe probably a decade or so. So market is a second factor. And third factor is the competition. How is your competition moving about it? Say, for example, if competition is going really, really aggressive on your home turf, then essentially you really have no time left and you really need to react in a big way. If you are, if they are the people who are also not really focused on your key markets, probably you can take it easy. If you are trying to enter into their domain, then there is a problem. Or even if you are two big companies, then you essentially want to secure freedom to operate or freedom to sell going forward. Uh, so irrespective of what your competition is doing in that case, you really need to you really want to have several high quality patents filed every year, so that your future technology, future products are not really threatened by your competition. So broadly, there are three components we are talking about, starting with the purpose. Second is the market, and third is what is the competition doing there. And when we come down to manufacturing companies, so typical innovation in a manufacturing company would happen on the process side. And when the innovation happens on the process side, it really leads to two kind of patents. One is process patents that are not detectable looking at the product. Second, process patents that are detectable looking at the product. And I'm not saying one set of patents is inferior to other patents. It again comes down to the purpose. Obviously, if we make a change in the process and the change is reflected in the product, then it's pretty easy to establish infringement, pretty easy to go against the competition, or pretty easy to really establish infringement in the court, if that is your objective. However, if your objective is really weak, they don't have to, and they're way smaller in size compared to what I am, or I have real deep pockets, I really won't mind having a lot of patents on process which are non-detectable in nature. If my purpose is just to deter three litigations against them, uh, even based on certain assumptions or certain calculations or certain lab tests, the likelihood that these people would be infringing this particular non-detectable process patent, that's essentially good enough to deter them. So it's all boils down to what is it that we are trying to achieve. Having said that, most processes would have some kind of result that will happen on the product side. So I would really suggest that when we are building up a portfolio in a manufacturing organization, it's better to keep process patent and product patents really separate. The moment we mix it up, it becomes really difficult to enforce it. Say, for example, I'm making certain product. A part of the manufacturing process is being outsourced to a third party. Though there is an infringement of process as well, and it's detectable as well, but when you go to a court for a litigation, there'll be three different parties that you will be litigating against. So it becomes really, really difficult in that case to go about it. So there are three. So essentially, it boils down to three set of patents that a manufacturing company need to have. One is a product patent that is really common to every company that is there. If you really want to continue to sell your product going forward in future, irrespective of whether you are in India, whether you are in China, whether you are in US or Vietnam, it really doesn't matter. Especially the kind of inflection point we are seeing in India, China has already crossed that barrier. So process product patent is something that is must have for any manufacturing setup, product patents. And on the process patent side, as long as it is detectable, it is probably as good as the product patents. If it is non-detectable, then it depends upon the purpose that you are trying to achieve. Nutshell, if we were to conclude whether it's important or not, so I would rather put it this way, that in one single line, yes, it is important for your survival, if nothing else. 5 years down the line, one patent infringement litigation can really take you out of the entire market. If if a lot of people might recall, there was a litigation between Bajaj and TVS several years back. So TVS launched Freedom Bike. Everybody heard about it. Bajaj had a patent on the engine design, spark plug design, and combustion chamber design. I'll not really go about in the merits of the patents. Irrespective of what the outcome was, they were able to secure stays. They were able to make sure that TVS is not able to sell into the market for 1 year. And that 1 year was sufficient for Bajaj Pulsar to capture the market anymore in the motorcycle segment. So that's the kind of impact that it can have even in countries like India. And right now, patent regime and the way government is acting, the way patent office is acting, it's getting tougher and tougher, really day by day, with respect to enforcement of patents. So yeah, Deepshika, over to you.
Yes, so that was quite an informative and exhaustive answer. My next question to you would be about a provisional patent specification. Now, what exactly is a provisional patent specification? How is it different from the complete patent specification that is required to be filed? And does it even help the inventor in any way to file a provisional patent specification? Should he take that step? Is it viable for him? So it's basically about what is a provisional patent specification and how does it help the inventor in filing it.
Sure. So I'll answer this question in a little reverse chronological order. Does it really help the inventor? Uh, if it takes application is something that just helps you secure the priority. I came across an idea, or I just developed a prototype, or I thought about something, and it's probably a year away from really testing the markets. I even say if I'm in a startup founder, I come across with a technology concept, and I really don't know whether this concept will really have a leverage in the market, whether investors would be ready to fund it, or whether it's really a viable even concept. So in that case, I would really don't want to spend too much on patent applications in the beginning. I would rather just curate this concept, put it in a data dump in some way, whatever best information that I can get, whatever data that I might have, I'll just put it, write it down, and I submit it as a provisional application. So that secures my priority. Having said that, when we say it secures my priority, it is more of a stopgap arrangement for an inventor. Period of 1 year wherein you can decide whether you want to continue it. If you want to continue it, we need to file a complete patent application. A complete patent application would have an entire set of components that are there in a patent application, right from claims to abstract to technical field, detailed description, brief description, drawings, abstract, everything. On the other hand, there is no requirement for a provisional application to have a defined scope. In that sense, to have a defined set of claims, it can really be whatever information at that point of time is available to you, or whatever you can think of. You can dump it in a dump it in a write up and submit it in the bare possible way. And does it really help the organization or an inventor? For a startup, it's a simple case, but for larger organizations, it does in few cases wherein you want to launch a product right away, or you want to supply a product to a customer right away, even before the test results are out, or you don't have enough time to draft a complete patent application. Helps them bridging this gap of the time. However, if we are really talking about enforcement from an enforcement standpoint, it adds another layer of I would say difficulty in enforcement, in the sense a defendant lawyer would have uh, another reason to say that the scope of this particular complete patent application is different or more than a provisional application. So it has its own pitfalls, own downward things that can happen, but it does have its own positivities and positive threats. So it's more of a balancing act, depending upon the situation, what we want to achieve. Viable or it is not viable, or it's a good alternative or bad alternative, depends upon why we are filing it and what's the purpose of it.
Komal, would you like to add something?
Yeah, so I just want to say that if anybody has any questions for Weber, you could send it to me by WhatsApp on 9167-125-177. That's 9167-125-177. Thanks. Please continue, Deepshika.
Vaibhav, the next question would be approximately how much money is it required, or how much does it cost to get a invention patent in India, and how long does it take usually from the date of invention to from the date of filing to the date of I get the certificate of patent protection?
Sure. So when we talk about filing a patent, cost of filing a patent in India, it's like really cheap compared to other jurisdictions. So there are different categories. One would be a startup, solo inventor, or single inventor, to a medium to small size company, to a large sized enterprise. And there also it is divided into two categories, whether this entire set of exercises they are done online or they are done in physical form at the patent office. So if you are doing anything physically at the patent office, fee is typically higher by say around 10% or so. And if you are trying to do it on online, say for example, filing a patent online for a solo inventor or for a large enterprise, it will range from official filing fee will range from 1600 rupees to 8000 rupees for a large entity. And if you are looking at cost of filing request for examination, they'll go from 4000 to 20,000 rupees from an individual inventor to a large enterprise. And there's another category that'll be in between that. It'll be cost somewhere between that. Over and above that, there'll be a professional fee that is required to be paid to, say, for example, a patent agent for drafting and filing a patent application for yourself, or it could be an attorney, or it could be a law firm. That can really vary from it could be as low as probably 30, 40, 50,000 per patent application, or it can go as high as probably 3, 4, 5 lakhs, depending upon who you are choosing and the complexity of the invention and stuff like that. And these are all the costings that we are talking about. We are talking about a standard patent application. That essentially means this official fee is for 30 pages of patent applications with 10 claims, 1 independent, 10 dependent claims. And these 30 pages are in the format of patent office, not in the format that we are writing, but in the format of what patent office is recommending. So every additional page, every additional claim, every additional independent claim will cost extra, and that price will continue to increase. So this is the upfront costing that we are really talking about. So the costing of filing patent really doesn't end here. So starting up cost could be really as low as probably less than 50,000 to probably 1-2 lakhs. The fee keeps on increasing going forward, in the sense if you receive a office action or a search report, responding to that or attending to a hearing would entail additional cost, professional fee, basically, majorly, that we'll have to incur. So that cost would be around, again, it depends. If we talk about a small inventor, single inventor, that fee could be around 20,000, or it can go high depending upon which law firm or which service provider we are working with. And then this entire process of maintaining this particular patent application for the span of 20 years. So there's an annual fee that need to be paid. So that continues to increase after every 5 years. It'll start with 4,000 initially till fifth year, from third to fifth year, then it'll go up to it'll continue to go up to around 20,000 in 15 years, and it'll go up to 40,000 in last 5 years. So the intent here is, if you are maintaining a patent application for 15 years or more, then possibly you see a lot of value, and patent office obviously want their share of the value out of it. So that's the typical cost.
And what about how long does an inventor have to wait usually to get his protection?
Right. So assuming that this patent application is filed by an Indian inventor, Indian citizen, and in India, and it's their first application, and they're going through national route, they're not going through PCT route or something. Uh, Legally, a statutory requirement would say that it would typically take any time between 2 years to 3 years or something like that. That would be the earliest it can happen. Uh, Otherwise, in given conditions, what is happening in India, there is a huge amount of backlog of patents that are there. So there's a significant delay between filing of a patent and grant of a patent, or final judgment on the patent. So from filing, on an average, we can say from filing to grant of patent would be somewhere around 4.5 years. If we are filing a patent now, if we had filed patent earlier, the years could be really, really high.
Okay, thank you for your answer. For example, if there's an Indian inventor and he wants international protection of his invention, for example, he wants to get protection in India as well as some foreign country or multiple foreign countries, then
Sure.
what is he supposed to do?
Right. So first, as a first step, inventors who is seeking international protection, uh, they have they have two options. Either they can file a patent in India, wait for 6 weeks. So, or if they don't want to file a patent in India, they can apply for they can apply for they can apply an application that they want a foreign filing permit, and they can directly apply outside India. But the cost of official fee of filing both of them is same, so you might as well file a patent in India first. And once we do that, taking to international routes, we again have two options. One, we can go for a national route where we can pick up individual country wherein we want to file a patent. Say, for example, if you want to file a patent, we have filed a patent in India and we want coverage in US and Europe. So then possibly once we file an Indian patent, we have 1 year from the date of first filing to file a patent in US and Europe. And that's a really fair deal. However, if we are looking at filing patents in multiple countries, or we are looking at increasing the time frame from 12 months to say around 31 months or 32 months, then there's another route that usually organizations, usually people can take. That's a PCT route. So you apply for a PCT application, you'll get a search report after around 31 months, and that's the time that you have to decide in which all countries you want to file, if you want to do that. So it's give you enough time, it gives you enough bandwidth, and it allows you to file in multiple countries, because because once you have the search report, you really understand whether this patent, what's the likelihood of getting this patent granted in multiple countries. Say, for example, you are filing in 10 different countries. In that case, probably 1 year might be a little less period for less time for you, depending upon the size of the organization. In that case, PCT route might be preferable for you. But the downside of a PCT route is twofold. First, it is costly route because you anyways have to file national phase applications. There's an additional fee you end up paying for PCT route. Second downside is if you get a negative search report in a PCT application, that's definitely going to impact your patent application in all those 10 countries. However, if you have gone through, this is more of a practical aspect of it. And if you're filing those patents in 10 different countries, they will have some bit of interlinkage between different patent offices, but will it have a direct impact on all rest of the patent offices? Probably no. So there's both an upside to and a downside of choosing a PCT route, depending upon why we want to achieve it, why we want to file that. Does that answer your question?
Yes, yes,
Sure.
that does answer my question. Wherever there are many terms like background, foreground, side ground, post ground, IP. So can you please tell us that what exactly do these cluster of terms mean?
Sure. So when we talk about these terms, we are basically talking it in a larger context of an agreement, wherein we are like kind of getting into an agreement with another party outside the organization or outside an inventor, wherein both the people might be contributing some kind of IP. They might, and it's kind of they're going to work together to generate some more IP out of it. And at some point of time, that agreement would end, or that term of agreement would end, and they might part their ways, or they might take their individual routes. Say, for example, if there are two companies that are getting into an agreement to develop a new product for a telecom sector, or probably an artificial intelligence powered mobile phone or payment gateway, something like that. These two companies come together. They say, I have IP on mobile phone working. Another company says, I have an IP on or a set of patents on how payment gateways work. And there's third company that says, I have IP on how artificial intelligence works. All these three companies come together. So the existing IP that they have before the date of execution of the agreement in which they are trying to co-develop something, that's called a background IP. All the IP that will be generated while they are working on it, while they are working on the project together, that will be the foreground IP, and where its ownership would lie, that will again a kind of topic of discussion between the people. On the side ground, IP is defined in several different ways depending upon what kind of agreement you are getting into. A side ground IP would be, say, probably an IP of an artificial intelligence company, the example that we talked about, IP that they have on application of artificial intelligence in, say, biomechanics outside telecom domain. That could be a side ground IP. Or in some cases, side ground IP can also be defined as, I have a artificial intelligence company having an IP on domains that are other than artificial intelligence. So it depends upon what is the context of it, and what is the agreement all about.
Thank you for your answer, Weber. The next question that I'd like to ask is what is a patent holding company, and how are they used in the management of a patent portfolio, and the balance between the control and ownership of patents? What is the role that a patent holding company would play in that?
Yeah, that's an excellent question, in fact. So this is a question. I mean, this is a question which is more relevant to very mature IP mature organizations. Patent holding company is typically a separate legal entity which holds uh, IP assets. It could be patents, it could be trademarks, it could be copyrights, it could be some other kind of intellectual property that they might have. The purpose of creating an holding company, it's manifold. First intent would be, uh, a first and most common intent is, if a company who has generated a lot of IP, they want to really license out those IPs. They want to get into a forceful license or mutually agreed kind of a license, they would, it's preferable that they park their entire set of patent assets into a holding company, so that when the licensing is happening from a holding company, any kind of counter litigation that might that might happen, that will be restricted only to the holding company, and the parent or manufacturing company is not affected by it, or vice versa. If there is an litigation that happens on a manufacturing company, and so the entire liability or entire revenue stream that is being generated out of licensing of your patent, that will also get sucked into it if it is a part of the same company. If the IP is part of a separate holding company, any litigation that is happening on manufacturing company or a parent company will not affect the revenue stream coming from holding company. Any litigation happening on the holding company because they are trying to license their patent to others forcefully or otherwise, it will not affect the operations of the manufacturing company. So it kind of is more of a risk mitigation strategy, and obviously it makes things very efficient for from the management perspective as well as from tax benefit perspective. For example, there would be a lot of companies, a lot of countries, a lot of jurisdictions that offers tax benefit on revenue generated through licensing of IP. But a parent company might be headquartered somewhere, say for example in India, which has limited, now with patent box regime things have changed. But for example, in certain jurisdiction like say Bangladesh or somewhere, that's where a parent company, manufacturing company is situated, and they are able to really license out their patents, but the revenue stream coming through licensing of their patent is taxed at a corporate tax rate of say around 33%. But in countries like countries like say for example Luxembourg and all, your entire licensing income from licensing of IP is 100% tax free. So a holding company can be formed in those countries wherein then entire licensing incomes remain tax free. So it serves two purposes. First, it mitigates the risk from crossing over from parent to holding company to a parent company. And second, it is a very tax efficient structure which really has multiple financial benefits from several different ways. So that's how it is being typically used in the world today.
Thank you for your answer, Weber. The next question is that there's a term called patent trolls. So what exactly are these patent trolls, and how can one save themselves from getting trolled and from getting, defending themselves from such patent trolls?
Right. So again, this is more of a logical extension to the question that you asked earlier. Patent trolls again are typically holding companies of patent. They might have developed, or they might have acquired those patents from anyone who is willing to sell. Could be from banks, could be from universities, could be from companies, and their entire business model is acquire those patents and license it to the people. And when we are talking about license it to the people, mm, uh, we are not really talking about pure play bona fide license. We are really talking about more of extortioning money from the people. It would be something like a law firm in US, they might have a patent on say wireless. They might really go about asking royalty from pretty much all the wireless broadband providers or maybe router makers or somebody, but they might also scoop down to the level of a restaurant using a Wi-Fi router to license their patent. And the model that they typically use is uh, they would they are not the people who really want to go to the court and take the this litigation to a final level. They are really not bothered whether this patent is valid or it can be invalidated, whether infringement is happening or not. Their model revolves around the fact that whether or not you are using a patent, whether or not that particular patent is valid or invalid, you still have to go to court to prove it. Going to the court is both hassle as well as costly. They would rather prefer to settle at a price which is less than your cost of going to the court. Say, for example, I'll draw upon the experience that we had in one of my previous assignments, wherein a patent troll approached us and saying that you are using this particular CD DVD patent and you need to license it out from us. They filed a litigation against us in US. Obviously, we were not using that patent. That patent was really nowhere really connected to us. Their intent was their ask was very simple. You are going to spend probably close to $500,000 in proving it in the court. So why don't you settle at a price probably 20%, 30% less than that amount? So that was what their value prop or what their offer was. And this brings us to your second part of your question: how do we deal with them? So these are the people, typically lawyers, for which legal cost is zero for them. They are the people whose bread and butter is that, and they might or might not really be concerned about whether or not infringement is happening, whether or not validity of a patent is there. So from that standpoint, unless and until we can increase their cost of fighting the litigation, there is typically no way to manage them, because for them legal cost is pretty much zero to a very large extent. So the way we had increased their cost of litigation was, once they send us this notice of infringement and they send us the offer for licensing, what we did was we send them technical documents saying why this is not and why we are not infringing, worth 7,000 pages of technical data saying why we are not infringing. And to be really honest, was all that entire 7,000 pages of technical data made sense? No. Was it even related to the patent? Some of it, yes. Most of it, no. But whether what we shared with them is relevant to them or not, it is something that they need to hire experts. They need to really understand it, and they really need to take it forward from there. So from that standpoint, their cost of litigation also goes up. And the moment their cost of litigation goes up, you have a lever to fight with them. So that's how we were able to manage it. However, if we go about a little mature IP organizations, then there are several other mechanisms to manage patent trolls. There are several pools or several insurance companies that take care of this kind of litigations. And a pool could be a patent pool that is working against these kind of patent trolls. Would be if you become part of these particular pool, you contribute certain patents or you contribute in terms of money, and these are the people who buy distressed patent, important patents, and keep it to them, and they license it out to the entire group. So you can be part of these kind of pools to do that, or there are insurance companies that would say that if you get into a patent litigation, we'll cover you for X amount of cost or depending upon your negotiations. So these are things which are available in mature markets for mature companies at a price. And having said that, in current context, this is a menace that is on very, very significant decline because of a lot of action that has been taken up by US Congress in last almost 2.5 years. So this menace is pretty much on decline and probably will not be as severe as it was earlier. So probably it will not really figure out on really high priority list for most of the organization in next couple of years at least.
Okay, so that was a great answer. Thanks, Vaibhav. So that just explains about that there can be somebody called trolls in patenting as well, and who they are. Thanks a lot for that answer. So the next question that we have here is, if you are an inventor at a university incubator, how would you ensure that your invention is can be commercially exploited? Now, university incubators. This is probably not that common in India, but like
Mm.
given that it may develop, and I think this is prevalent to a great extent in US, if I'm not mistaken.
Yes, if I may interrupt, like there's StartX by
Mm.
Stanford.
Mm.
So, these are the types of references that we have taken. Like,
Right.
so how does it work in India?
Uh, Typically, like Komal rightly pointed out, in India, this kind of an ecosystem hardly exists in Indian universities, at least for now. Having said that, we are not saying that this will not happen in future. I'll just take a step back to be able to answer this question in a more holistic way. When we talk about universities outside India, typically say when we talk about US universities, their professors are typically not kind of evaluated based on the kind of teaching they do or the kind of research they do. They are typically, and or for all practical purposes, they are evaluated on how much of industry fund they can get. And the kind of industry fund they'll get only when they are doing some research, they are doing some patent filings, they are some doing some development of certain technologies which have commercial importance. So that's the reason this kind of a setup has really evolved very well outside India in their universities. And when an inventor is working in these kind of universities, uh, typically these universities would have technology transfer office which take care of all the agreements to be signed by inventors. They are the people who try and commercialize these technologies. These are the people who try and license out these technologies, these patents. Say, for example, if I'm a PhD student in a certain university working in certain supporting certain incubation of certain technology, and I filed a patent on it, my technology transfer office would be, if it's a European office, they'll typically be looking out at selling out those patents. And the kind of agreement that I've signed with the university, if we are really talking about some good universities, Ivy League and top universities, that agreements allows certain part of that royalty or a sale to come back to me. There'll be certain part that will go to my department. There'll be certain part that will remain. The majority of it probably would remain with the university. Uh, for example, for example, uh, in a typical university setup, if my patent is sold by a technology transfer office to another company, and these things are not really uncommon, these things typically happen, then around 70% of that amount, 65 to 70% of that proceed would go to university. Around 20% would go to my department, and rest of it might come to me as an inventor. But again, as an inventor, as in part of that incubator, it's my duty to really understand it, whether this agreement that I'm signing with technology transfer office or the university, does it supports it or not, or they have a different policy out there. uh, for example, if we talk about, say, again, it's a little cliche example, but if we talk about Mark Zuckerberg, when he started Facebook, when he filed his first patent, he did not file that patent. He was part of the university, but he did not file that patent in the name of university. He filed up the patent in his name, and that patent still remains in his name. He still has probably 4 patents in his name because of certain objectives that he wanted to fulfill. So, from that standpoint, it really boils down to a policy of the university. And second thing, it boils down to the choice that inventor makes, whether they want to do it within the within the university incubator or as a personal intent. So it's a combination of these two things that we really talk about in terms of safeguarding your interest or safeguarding commercialization part of it with respect to university. And if we are really talking about spinning off a company around it, then unless this entire IP is shifted to the company where you hold certain equity rights, which is controlling, you might be losing out the entire IP to the set of company on which you might not have control going forward. So these are the kind of agreements, kind of things that you really need to keep in mind before you assign your patent to a university incubator, or you work in a university incubator wherein they are trying to either commercialize the IP or they are trying to even sell the IP. So that's the kind of choice you have to make and the agreement that you sign with these people.
Thanks a lot, Vaibhav. Deepshika here is having a bit of internet issues,
Sure.
but we'll go on with it.
Sure.
So, Deepshika, are you back?
Yes. I'm just
Okay,
back.
okay. Could you take on with the next one then, please? Which is monetizing by the Indian companies.
Okay, so how viable is monetization of patents by Indian company? Viable? Is it a good viable avenue getting patents? So
So
how can a company
mm,
get patents and
mm,
then use it as a viable monetizing avenue and earn money through their patents actually?
mm.
Is it
So when
possible and how are they supposed to do it? Yes.
sure. I mean, from an Indian standpoint, from an Indian ecosystem, uh, when we are filing a patent, if the purpose is to monetize those patents, to license out those patents, to get a hard cash out of it, so there's a different set of patents that you will be filing. Uh, for example, you'll be filing patents which are likely to be used by people. You might or might not have a product on them, or your product might be different from what you are really manufacturing or selling, or for that matter, you are really filing an overbroad patent with some bit of limitations added in the dependent claim just in case something goes wrong. So the content of the patent as well as the way patent is drafted, that gets really different if the intent is to license out those patents for hard cash or for royalty. So that's what we spoke about. And second thing, how we can go about it is, typically if we have to license out our patent, the we as an organization or as an individual, we would want to make it a very robust patent with respect to its validity, because at the end of the day it's very likely that it will be challenged in the court. And to be able to overcome this kind of a challenge, we probably need to augment it with several number of patent filings to ensure that it really becomes unviable to invalidate probably 10 patents or 8 patents. So that is another area that we need to keep in mind from the filing strategy standpoint. When we come to real monetization bit of it, then essentially we can go about it as a directly against the infringers through a law firm. But typically in India, law firms are not allowed to be kind of license out patent on, say, success fee kind of a basis. A law firm cannot say that I can try and license your patent and I will not take a fixed fee. I will take probably 10% of the licensing revenue. It's something that's not really allowed in India. So that makes a licensing through a kind of a lawyer for a small entity kind of little difficult, unless and until you are really sure about its validity of a patent, you are really sure about the infringement, and you are really ready to fight it out till the end. If you are say for example a medium sized company, then it might be viable option for you. When we talk about a smaller company, there would be certain there are certain available that really do it in US and Europe kind of jurisdiction depends upon, you might be an Indian inventor, you might have an Indian patent that has counterparts in US and Europe. And if it's a really a good technology patent, cutting edge technology patent, that's probably your infringers might really lie. So if you are looking at that kind of a model, licensing out your patent outside India in US, Europe, or probably in Japan, there are several law firms, several groups that will really do the work for free. When we say for free, that will be on success fee basis. You don't have to pay anything upfront, and you can really go about it. There are companies like Acacia who would really buy out your patent for X amount. They'll evaluate your patent for X amount. They'll buy it out. They'll license it at whatever price they want to, so you have no business to be there thereafter. Or there are certain there are certain individual for a small company, there are certain individual lawyers that we can find in US and Europe. Now that in current situation, that is really a difficult task that probably won't happen anytime soon, but that again remains an alternative wherein people are willing to work on a success fee basis or a limited upfront basis, wherein they'll do that. Or there are many groups that will buy out your patents. There'll be companies like 3M who will buy out your patents if they see value in that. In fact, if you log into their homepage, the homepage says if you enter your patent number, we'll come back to you if it has any value to it. We might really end up buying it. So these are the kind of monetization models that are available for small to medium size or individual inventors. And if you're talking about large enterprises, large companies, large Indian companies really doing it, so then I think Bajaj and TVS model has really established that these are the kind of things that can really happen in India, and they can really be taken to a conclusion to a large level. But again, we got to be really sure before getting into this kind of an enforcement, this kind of patent enforcement in India. Even if we have deep pockets, we need to be doubly sure about um validity and the infringement evidence that we have, doubly sure about that we can fund it over the period of next 3 years or 4 years, and we can take one step at a time, right from district court to high court to Supreme Court, and maybe going back to IPAB or even patent office. So from outright enforcement for monetization is something that really needs to be thought about and really need to be committed to it if we really want to go about it in India from the monetization standpoint. So does that answer your question, Komal?
Hello?
Yeah, that helps in the sense that if for even for a small or someone who's a relatively smaller entity can just log on to a website and try to monetize his patents, that's something that's really helpful. Thanks for sharing that information. And we can move to the next question here, which actually deals with the licensing part of the patents. And that is that how to approach a patent licensing deal when you are on the receiving side. So we're talking about a deal here when you are the recipient, when you are on the receiving side.
Right. So first thing is when you are on the receiving side, then got to be, I mean, that will depend upon the context that we are really talking about. If you are an Indian company on the receiving side approached by a foreign company which has several patents in India, and you don't have any counter IP to them, that could be one situation. Another situation could be you are probably as big a company with really equal or strong IP, counter IP to kind of balance it out. So these are the two kind of situations that we will talk about. So let's take a situation wherein you are on receiving side and you don't have an IP on that, a counter IP or IP to be able to cross license to them, or an IP to be that you can enforce against your adversary. So in that case, there's not you obviously start from a position where you have absolutely no leverage against your competition. So there it all boils down to the kind of preparation that you do. When we say preparation, so that is, I would really talk about stake management. So when we say stake management, you are really saying that you need to increase the stake of the company who is trying to enforce a patent on you. And because you don't have a counter patent, you have limited ability to do that, but you can really work it out. When we say you can increase the stake for other company, it typically happens in a way at the preparation level. Say, for example, an Indian company is approached by a Japanese company that runs a global licensing program on certain set of patents. An Indian company doesn't have any counter patents. What they can really do is they can understand the patents that are really being infringed. They'll come to you and say you are infringing, these are 100 patent of ours, so probably you are infringing them, and we need to talk about licensing and negotiating a deal with you. So it all starts with the fact you need to understand whether we are infringing those patents are really being infringed by your products. When we say patents are really being infringed by those patents, you're essentially saying whether your products are mapping onto the independent claim of those patents. So when they come out with several hundred patents or maybe 100 odd patents, you'll realize that the list would really boil down to maybe 2, 3, 4, 5 patents that you would believe that you are really using. And a lot of those patents would be a lot of those patents that you will be talking about that you are likely to infringe. A lot of it would depend upon the things that are being outsourced at your end. For example, I'll take an example of a mobile phone. If you're talking about a mobile phone, manufacturing company in India, for example, I'll not take names, but yeah, if you are a mobile phone manufacturing company in India, a company comes to you saying that you are infringing my 100 patents. So out of those 100 patents, you really figure out these are 5 patents that we probably are using. These are the 5 patents we really don't know whether we are using it or not, because they are talking about some encoding, decoding, or modulator, demodulator, which are built into a chip that we are buying from Taiwan or we are buying from somewhere else. So that is, we are really not sure whether we are doing it or not. First thing in these negotiations is to be able to understand, to go back to your agreements and see whether you are being indemnified by those suppliers that you are using. So it is very likely, if your legal and IP team is really have done a good job, then in all your agreements that you are sourcing certain technology components, you will have a clause wherein all your liability is being taken care of by your suppliers as far as product supply by them is concerned. So that'll typically be an indemnity clause that will be there in your agreement. So that's one thing that you can leverage. Second thing that you can leverage is you can really try and invalidate their patents internally, and say if there are 5 patents that you have really shortlisted that you think that you might be using or you are using for that matter. So maybe 3 of them you will figure out that you really have very strong prior art that you believe that can really invalidate those patents. And for probably 2 of them, you might really want to work with your vendors, your suppliers, or larger group to identify those invalidating prior arts. And those invalidating prior arts might exist if it's a technology product, depending upon which technology we are talking about. A lot of those invalidating prior art might exist in Japanese language, Dutch language, German language, French language, for which you might or might not have English translation available. So these are the typical two levers that you use. First, you try and distribute your liabilities. You can say that there are 10 different parties that I buy this component with, and all of them have indemnified me. So from that standpoint, this litigation can really become a complex job for a enforcer. Again, this is not a sure shot way, but this increases the complexity for the enforcer of a patent, and it transfers some of your financial liability in case you lose the litigation. Second thing is, you try and build up invalidity arguments, and when you try and build up invalidity argument per se, they still have don't no leverage against the enforcer, as long as you can say that, for example, unless you can create that kind of a high stake game for them. And the way you do that is, you can, if you really have good invalidating prior art references, then you have a real case that we are ready to go into the court. And if we go into the court, and just in case this litigation goes against you, your entire global patent licensing program could under threat and could be under threat. You might get some X amount from us, but you are again getting X amount from 20 different people. If you lose a litigation here, you might not be able to get that royalty from others as well. So this is how you try and increase their stake in litigation. By increasing the number of parties that might be involved, transferring your financial liability to those parties, your suppliers and others, cascading it further, and increasing their entire licensing, increasing the stake on their entire licensing program, which can really go against them in case they end up losing. And to be on a very practical note, if we are fighting a patent litigation, irrespective of how strong evidences are, things can go really against us, and irrespective of how weak arguments we might have, things might still go for you. So there's still a bit of uncertainty that remains, and that uncertainty really boils down to who has a better lawyer at the end of the day. So that uncertainty can play both ways. Even for an enforcer, it might really become difficult that this guy probably has really good invalidating prior art references against me, and he's the guy who is ready to go to the court. He's not really budging. In that case, I might really want to settle at some middle path or some price at which is acceptable to them, so you can bring it down to a very significant level. And when you are trying to bring down the licensing fee or the royalty to a very significant level, then friend obligations kicks into the place. And fair, reasonable, and non-discriminatory licensing that they are supposed to uh, terms that they have to provide to all people, and these are applicable to patents that are part of the standards. So they cannot do that. They are licensing a patent to you at X royalty, but they are licensing this same patent to your competition at Y royalty if they are patents that are part of the standard essential patents. So these are a couple of things that you can really do. At the end of the day, it boils down to your preparation, initial study, initial research that you have done, how you are able to convert that research to increase the stake for them, for the enforcing party, if you have nothing with you. And in case you are an organization where you have a lot of IP that they might be using, it becomes more of a kind of, if you sue me, I can also sue you. So get to an equilibrium, usually in some way, probably by fighting a violation, or even probably that might not be required. And some companies have done in past, and they have done it very successfully, is they have bought patents from universities or from other companies which are being used by the enforcer. It's something like, I'll take an hypothetical example. Kodak for example, a company like Kodak, who has multiple product ranges, their lighting, organic lighting side of patents might come to you, say that you are also manufacturing organic lighting. So you need to take license from us. You might try and find organic lighting patents in the market, but you'll figure out that probably the patents that they are infringing, they are really either not available or they are really, really high. So in that case, you might really find out a patent which is mapping onto their mainstay of their product, like camera, for example. Not really applicable now, but yeah, it could be on the camera. So you might acquire a patent on a camera which you think is really valid, and it is being infringed by your enforcer. So then it creates some kind of an equilibrium, and you are able to settle either out of court, or it could end up in cross licensing. So it all boils down to if you can increase their stakes in some way. So that's how you can really either negotiate a license, or you can really get away with it, or you can really cross license it, or in some cases, even I mean, drawing on my experiences, we have done licensing from companies wherein we said we'll not pay you money, but because you have licensed this patent to our competition based out in Taiwan, and they are the people who are misquoting you the numbers, and their volume is really, really high compared to what you will get from us. They are probably 10 times the size of it, and they are really underquoting the numbers. And we can actually tell you the right numbers with the right data. We can even give you certain information. So you give them something, or you raise their stakes. It all depends upon if you can do either of these two things. So
Okay, that was really useful for a negotiating strategy for someone who is going to be negotiating the licensing deal. So Weber, you mentioned in your discussion something called standard essential patents. What exactly are these and how do these work? We are running a little bit over time here, but we'll have just time enough to cover two questions. And one of that is what are the standard essential patents? We would like to know this from you.
sure. So when we talk about standard essential patents, are the patents which are kind of incorporated in the standards. So for example, there could be several standards governing a product. So it could be a standard could outline the output characteristics of the products. A standard could be on the way that product is tested to be qualified as compliant to the standard. It could be about the outcomes that might really happen if we are using that product. So it depends upon what the product might be. It could be on the specific of the product. It could be on the product geometry. It could be on the product design. It could be on the product composition. So it depends upon in which category we are operating in. So for example, when we talk about CDs and DVDs, we'll have standards that will specifically define what should be the groove geometry, what should be the laser beam length, how it should be tested. So there'll be several standards on several different products that'll really come into play. And when we talk about standard essential patents, because these are the standards that are being formed by standard setting bodies, for which many companies were part of it. So those are the companies that would contribute their technical knowledge on defining what should be the standard. And many a times, or in fact, pretty much all the time, these are the companies that would have patents on what the contribution that they are making to these standard making bodies. So once their contribution get accepted and it becomes part of the larger standards, anybody who is complying to those standards would end up using their patents. So those are the patents which are standard essential patents. From a definition standpoint, to a layman, if we need to explain a standard essential patent, it would be any patent and any patent that is part of the standards that is being used by a product. So that would be a standard essential patent in broad sense.
Okay, thank you for your answer. Yeah. So one last question to you would be that one thing which is very a topic of great discussion is the patent wars. The big giants on technology, these smartphone company owners, they usually get into these patent wars.
Mhm.
So, why is that these patent wars are so prevalent in the last decade, and what are these trends in the wars between different smartphone giants, and
Mhm.
what are the impacts and outcomes of the same?
Mhm. So, right, talking about why these wars happen, uh, let's put it in more of a business perspective to be able to answer this question. It would be something like, if I am a CEO of an organization, and it was a pretty successful company. We have a big portfolio of a patent, and we have been using these patents for various purposes, for cross licensing, for ability to operate in markets and all that. At some point of time, this technology starts decreasing or getting into obsolescence. At that point of time, as a CEO, what's going to happen is my revenue would start decreasing, my sales might start going down. However hard I try, I'm not able to pick it up. So I am losing revenue to be able to kind of compensate for loss of the sales. So typically, this is one of the triggers that might happen. Once I do that, I would really be looking at patent as a tool of monetization. In the sense, this is something that this is a product that has gone into market. Say, for example, let's take this Ericsson and Indian mobile manufacturers, what they faced. So again, lot of things have been drawn from the questions that I've answered earlier and you have spoken about. So Ericsson was part of standard setting body that developed protocols that really helps mobile communication. He contributed those patents to the standards, wherein everybody, at the end of the day, when it becomes widespread, it kind of reached to a level of mass adoption. Everybody started using those standards. When it started using those standards, Ericsson shifted their patent portfolio to a patent holding company. They separated their mainstream business from the licensing and monetization standpoint. Once they did that, and you see that 4G or 3G is on decline, and 5G is coming over, or 3G is on decline, 4G is coming, 5G, 4G has already come, 5G is just around the corner. So any patents on 3G would have no value probably 5 years or 3 years or 2 years down the line. That's another trigger that might happen to me. So once I sense it that these patents would not be valid or would not be useful anymore, so I would really want to extract maximum value out of them before they really become obsolete. Or my sales are going down and really want to increase my revenue, I would monetize those patents to compensate for that loss of sales. So these are two typical and most common scenarios when these kind of things intensifies. So for example, now we are talking about artificial intelligence, deep learning, and other deep learning and industry 4.0 and analytics coming into play. So this is these kind of technology developments that have happened, virtual reality and all. Lot of patents on existing technology will not be useful probably 10 years down the line. Lot of patents on how, say for example, automobile operates. Lot of patents on that operations. I mean, inner working would remain the same, but how the sensors are going to operate, or a driverless cars might come in. So a lot of patents that relates to driving of an automobile or assisted driving, what we would say right now, those patents will not be of any use going forward because the entire technology is going through a different change. So from that standpoint, this is one of the trigger that will happen, that these set of patents on which I've invested probably $1 million or 5 million or $10 million, these will be of no use going forward. So let's get residual value out of it before they become obsolete. Or for a company like Nokia, their main business is going down, so it obviously made logical sense for them. They had a big patent portfolio, why don't we transfer it to an holding company? Let's try and monetize it in different ways. So they've started going down that route already. So these are two most common triggers that we really find in terms of these kind of things will happen, or these kind of monetization will happen. And these kind of monetization would also really becomes more prevalent when patent enforcement regimes become tighter. So in India, these are the regimes that are becoming tighter. Ericsson has sent a new benchmark there. So it will become easier and easier for people to enforce patents going forward with Make in India. Everybody wants tighter patent regimes in India as well. Even Indian companies who are filing several hundred patents every year, they want it because it gives them an edge against the competition. If you talk about China, uh, all the news apart, but for all practical purposes, I would, from a patent enforcement standpoint, at this moment of saying, I would not rate China lower than US in terms of enforceability of patents. They have patent infringement litigation in China are several times more than what happened. Their success rate of foreign companies against domestic companies, it has risen many fold. And when we say many fold, around 7-8 years back, last year the success rate of foreign companies against domestic Chinese companies, it is more than 60%. And lot of litigations between US companies. I'll not really quote it because of whatever reasons, but a lot of US companies are choosing China as their venue for fighting their US wars. So China has already gone into enforcement is really at the levels of US and Europe. US and Europe were already there. India is also getting into it. And now with new technologies coming into play, there is a real likelihood that a lot of technologies would become obsolete going forward in next 5 years kind of time frame. So these are the kind of things that will really spike up in real future across the globe. And what spike we are talking about? We are talking about real spike by real patent owners, not by patent trolls.
Okay.
So does that answer your question, Komal?
Yes, yeah. That was great, Weber. We have gone beyond the time a little bit, but anyway, that was really helpful because you had a lot of live examples that you put in your answers, Weber, and that will be something that will be really useful to the participants. They'll be able to, relate with the help of those live examples.
Sure.
So thanks a lot, Weber, for sparing your evening for us and sharing your knowledge with us. And let's if the participants have any questions, by the way, Weber, or if the people who are viewing, if you have any questions, you can relay them to us, and I'm sure Weber will help us to answer them later. Yeah.
Sure.
So thanks a lot,
for
Weber.
giving me this opportunity.
Yeah. Yes, Weber, you were saying something.
I was saying that thank you, Komal, for giving me this opportunity. Because as an IP professional, it's really important that we go beyond the theory. We get to understand how this can really be put to use, how it creates value for professional itself, or how it creates value for the customer of a law firm, or for an organization, or for a CEO, or for a balance sheet. So that was my intent. That was my real reason that I agreed to do that, and I'm really happy that I'm able to do that. In case there are any questions, feel free to get in touch with me later through Komal, and I'll be happy to answer that.